Ladies and gentlemen, good afternoon. It is on behalf of the Center on Conflict, Development and Peacebuilding that I'm happy to welcome you to today's debate. We are going to have an academic debate on issues related to apartheid in Israel, and we have the privilege and the honor to welcome two distinguished colleagues. On my right side, Professor Virginia Tilley, who is Professor of Political Science and International Relations at the University of Southern Illinois in the US. Professor Tilley is the co-author with Richard Falk of the already famous, if I may say, report which was circulated for 24 hours and then pulled back by UNESCO last year, March, if I'm not wrong. Professor Tilley, and by the way, the report is accessible because on the website of the Institute for the invitation and the event, it was possible to download the report. So in case you want to read the full report, it is available. As I was saying, Professor Tilley teaches on different topics, particularly on comparative studies of ethnic conflict with a special focus on indigenous people. She has been doing fieldwork in different geographical regions worldwide, in particular Central America, South Africa, and the Fiji Island. For the past 30 years, she has been working on Palestine, on issues related to Israel and Palestine, and she's the author of several books. One of them, a few years ago, a very important one on the one-state solution. After the presentation of the report by Professor Tilley, we'll have Professor Robert Roth, who is Professor of International Criminal Law and the Director of the Academy of Humanitarian Law and Human Rights of Geneva. Robert Roth is the author as well of several books, but one maybe important thing to keep in mind, he has been as well president of the trial chamber of the Special Tribunal in Lebanon. So both our guests have an extensive knowledge not only of the region, but also a practice as international lawyers on very relevant issues. So for the presentation and debate, we'll have first a half-hour presentation by Virginia Tilley, then we will have a 15-20 minutes presentation by Robert Roth, which actually will comment on the report, and then the floor will be yours for Q&A. Professor Tilley, the floor is yours.
Thank you very much. All right, may I? Okay, am I projecting properly out there? All right, well, first I want to express my great appreciation at being here. I've been touring in sounds like the Tour de France, speaking at a number of universities in France about this, this topic. But I've had my eye on this talk in particular because of the quality of the Institute and your research. It's a great opportunity for me to share these ideas with people who are specialists in this area, and I'm sure that I have a lot to learn from you as well in regard to taking the report forward and considering the implications. I do want to talk about the implications of the report in this talk. First, I will be sharing with you a number of points about the analysis itself. Of course, I can't summarize the report. It's not actually very long, and it was written for a general audience, so those of you who have an interest in it, I hope you will take half an hour to look through it, at least to the main findings. consider the analysis. I've looked at this for a long time. I started working seriously on apartheid in 2005, on the question of apartheid in Israel. And the more I look at it, the more important I think it is. It seems to explain a great deal. So I hope you will give it your consideration. And then I want to move on and briefly consider some of the implications of the report. This is the area where I think we have a good deal of research to do, and there's a lot of interesting people who also are starting to explore what this signifies for the conflict's future and its resolution, hopefully. The idea is that this is applied theory, not just theory, although I have great fondness for theory. So that's the gist of the report today, and I'll try to get through it in a timely manner. Some of these, that means I'll be rushing through some points, but I hope we can come back to those in the questions if you feel that they've been too much neglected. Okay, this analysis is based on three general sources. The first is my book from 2005, where I talked about the end of the two-state solution. It was narrowly focused on that question. It didn't get into really anything else except that we should stop expecting Israel to withdraw from the occupied territories and explaining why we should do that. And I think it stood the test of time. Most of what I said I expected to happen and expressed in that book has happened. So it's a rare treat when academics find that their predictions worked out. We generally try to avoid predictions, as you know, because they're so fraught with peril. The second source is a report that was commissioned from me through the Human Sciences Research Council by the South African Department of Foreign Affairs. I had gone to South Africa in 2005 to examine the question of whether the apartheid model or paradigm applied to Israel, and through the good graces of the minister, was able to put together a legal team to do that. They really wanted to know, understandably, the government of South Africa, the post-apartheid government, wanted to know if Israel is indeed practicing apartheid. And that study, which was later published under the title Beyond Occupation, is really the in-depth legal analysis of the question. And those of you who work in international law will probably, I hope, find it rewarding. It would have resources for you that the later report didn't have time to do. But it is rather a dense legal read, so those of you who are not specializing in international law might find it a bit slow going. But finally, there is the report that drew such a frenzy of media coverage. It was really quite an extraordinary experience. My phone was ringing from Brazil and Moscow and India, and it got everyone was quite, excited both about the report and about what happened to it, which was that it was promptly pulled off of the UN website, and thereby drawing a great deal more attention than it probably would have drawn otherwise. But what I'm going to talk about in this today is mostly from this third report, but it draws heavily from the second report and makes some assumptions about the conflict that are reflected in the first book, so they form kind of a triad in that respect. One of the first things we had to think about in considering whether Israel is practicing apartheid is, what is apartheid? We find this term being thrown around quite loosely. It can be used in activist polemics, or in even by scholars it can be used very widely to mean anything that kind of rings of racial segregation and domination, especially when that becomes sort of a structural situation. We've also see it in discourse about the conflict in terms like apartheid wall. That's kind of a common term these days. I've also seen it used for global patterns of wealth and poverty that have racial components to them, like global capitalism. But the problem with all of these is that that's fine. All of these usages are fine as far as I'm concerned. If you're trying to explore challenging questions of discrimination and oppression. You can use any term you like to evoke some of those meanings. But if we're going to argue that something is happening on the level of international law being a crime against humanity, as apartheid is, and that states therefore have an obligation to act to end that practice, or that it should somehow impact diplomacy and international relations on a formal level, we do need to turn to international law where the definition is laid out, and get a bit more rigorous and technical about the definition itself. Apartheid is defined in international law principally in two instruments. The first one is the Apartheid Convention, for short, the International Convention on the Suppression and Punishment of the Crime of Apartheid, which was drafted in 1973, I think came into force in 1973, which in Article 2 defines apartheid as a series of inhuman acts, which includes a wide range of acts, including restrictions on movement and restrictions on labor, and the creation of racial reserves and ghettos. But these inhuman acts are only crimes of apartheid if they fit this overarching set of conditions which is presented in the opening paragraph of the definition, which you see on the screen. And there are several things I've highlighted in red for your attention because they stood out to us in the South Africa report, as well as for Richard and me in writing this most recent report. One of them is that these acts shall include similar policies and practices as were practiced in South Africa. But note the language there. It doesn't mean that they have to be identical. They do not exclude any other policies. And Southern Africa, also South Africa practiced, imported apartheid into the neighboring country of Southwest Africa, which was later renamed Namibia. So that's the reference to Southern Africa. It wasn't just the country of South Africa. So we have that reference to South Africa, but it's not a restrictive one. It's an inclusive one. The second is that these inhuman acts shall be practiced for the purpose of establishing and maintaining domination. That means that they can't just be a side effect or a kind of epiphenomenal outcome of the practice, such as when you have a literacy test for voting and it has an immediate racial impact. No, it has to be explicitly for the purpose of domination. And it needs to involve racial groups. The language is unavoidable in this case. This is not a broadly phrased definition. It is specific about being racial. And finally, there is this element of a system that is, by the way, was much stressed by the people in South Africa who had struggled against apartheid, that it isn't just a few laws or a few practices. It's a comprehensive system in which laws and practices, policies, ideology all work together to create a kind of a regime. And indeed, that term regime appears in the second instrument where the definition appears, which is in the Rome Statute of the International Criminal Court. Much shorter definition here. This is the entire definition. It leaves out that long list of inhuman acts that we see in the Apartheid Convention. And they proceed to label it as a regime. As was mentioned earlier, I'm not an international lawyer, I'm a political scientist, so I was playing catch up on a lot of the international law through a lot of this, but political scientists kind of get flushed with pleasure when you mention regimes because we've done so much work on regimes, so I felt like I was on home turf around that stuff. Looking at Israel's practices, we find that all of these elements are satisfied in a test of apartheid. We find them all evident. We find policies similar to South African policies, yes. Again, the definition doesn't exclude differences, but we do find a striking number of similarities, particularly in the administration of land. Racial, yes. This is a controversial point here. People who don't like the term apartheid, applying it to Israel immediately, one of the things they immediately mention is that this can't be racial conflict because it doesn't involve the racial categories we're used to using, black, white, Asian, so forth. Jewishness can include quite a spectrum in that sense of that typology of racial formations. And international law kind of falls short here because international law doesn't actually define race. There's an attempt to do so in one of the international tribunals. I think it's the International Tribunal on the former I think it was Yugoslavia. Might have been Rwanda. Oh, sorry. But generally, it kind of falls flat, and that's probably largely because racial formation is a sociological phenomenon. It's a matter of perception and belief, and more than it is neat categories. But international law does define racial discrimination, and it defines it to include a cluster of qualities, all of which allude to qualities that are considered to be immutable in people, things that they can't change, things that are seen to be intrinsic to them, such as, race is considered to be something someone can't change, color, national or ethnic origin, you can't really change your origin. And this concept of descent. L'ascendance in French, we kind of struggled to get that translation right. In this case, I mean, we can work around ideas of national or ethnic origin, but the principal way that the racial quality of this conflict is evident is through the idea that these are descent groups. It's particularly notable in Israeli discourse about the Jewish people and the origins of the Jewish people in the Palestine of antiquity, in the biblical narrative, and how that prior presence has both conveys a special privilege to the land and has been passed down through the centuries and carried on by the descendants of those people through the generations as a continual attachment and national longing to return. That's very eloquently expressed in the Declaration of the Establishment of the State of Israel, but it also appears in other instruments such as the Law of Return. By the way, I'm assuming some background knowledge in the room, which might not always be fair. So if you are a bit lost, we can come back to some of these. But the Law of Return, which provides that any Jew anywhere in the world can come to Israel and be admitted on the basis of their Jewish identity, defines Jewishness for the purposes of Israeli law as one of descent. I mean, it's a familial tie, a maternal tie, and that's consistent with halakha law. So for all the myriad debates about who is a Jew, Israel has taken a position on that has stresses descent. The purpose or intention to ensure racial domination was the easiest part to identify because it's everywhere. We see that documented everywhere. It's in Israel basic law. Israel has no constitution. It has a set collection of basic laws, several of which explicitly describe Israel as being a Jewish and democratic state. It is expressed in a range of fundamental laws. They really have the standing of basic law, but they're outside of that bracket, about Jewish national institutions, and I stress the hyphenated construction there, Jewish national. Jewishness can obviously mean many things, but in this case, the significance is to Jewishness as a people or nation. And in Israeli law, the Jewish Agency and the World Zionist Organization and the Jewish National Fund and these other Jewish national organizations are charged with an immense range of authority over distribution of the public resources of the state. And that is, there's a fascinating legal set of relationships there in which laws are nested within other laws in ways that confirm that Israel is a Jewish national state and should stay one. That's the primary function of the state, is to ensure that Israel remain one. And finally, it is the quality of a regime is something that we found pretty clear, and I want to explain how that system works next. But it does have that quality of a comprehensive, totalizing system of laws that ensures Jewish national privileges that dominate and oppress the Palestinian people as a whole. The way that system works was really a fascinating question. And I arrived, in working with Richard on it, we arrived at the term domains for it. It almost alludes to the internet, but the idea that it is a territorial division. These domains have a territorial quality to them. They also have a legal quality to them, sociological even, ideological. And that it's kind of just for those of you who study discourse analysis, it is a normalizing. It kind of normalizes a certain set of attitudes about these different categories. The first domain, of course, you could do them in any order, but the order we chose to use was that domain one was Palestinian citizens of the state. And this brings us instantly to the question that often, again, other question that regularly rises around the apartheid in Israel, which is that Palestinian citizens of the state have the right to vote. And black citizens of South Africa didn't have the right to vote, and therefore, saying, well, it's not apartheid because, look, they have the right to vote. However, there are other laws in Israel that restrict the effect of that right. It is not legal to form a political party in Israel that calls for Israel to be a non-ethnic state or a state of all of its citizens. You can't do that. And that means that while you can vote, you can't vote to alter the system of domination that is shaping your life and your life chances and the way that the whole country works. And obviously a problem here is, and I'll come back to this, but the problem here is that if you're going to allow people to vote, you have to make sure, any racial state such as white Australia or any other racial state has to make sure that that vote remains a minority so small that it can never threaten the larger system. And that is in fact what we see in Israel. I think the number of votes in the last election was something like 11% Arab. I mean, really small, far short of the 50% it would take to change a basic law, for example. The second domain is residents of Jerusalem, which fall into a different category. And I was just reminded in a conversation this morning that part of the function of these domains is to normalize for us that these are completely separate categories, that in diplomacy and law and activism and everything else, we treat these categories as not the same. They're not treated as being part of one question. They're treated as discrete questions. Palestinian residents of Jerusalem can vote in the municipal elections, but not the national ones. This means that you have roughly 300,000 Palestinians in Jerusalem who have no right to vote, again, on the crucial question of the Jewish national state, character of the state. Fascinating new development on that just this week, which we might talk about, that Palestinian residents of Jerusalem now can have their residency revoked if they demonstrate a lack of loyalty to Israel. I believe that was the word that was used. And that means that it's a direct threat. Basically, loyalty means supporting the Jewish national state, character of the state. So they've now made it explicit. What was always there in practice is now made explicit, it's codified. In domain 3, we have the familiar topic of Palestinian civilians living under occupation in the West Bank and Gaza. Now, technically, these include people in East Jerusalem as well. But again, because of the way the system works, we often peel Jerusalem out of that picture and treat that as a separate category. So most of the time, we find ourselves talking about the West Bank and Gaza. Crucially here, obviously these people have no right to vote, but crucially it's normalized for any observer that they shouldn't have the right to vote, that they are not citizens of Israel, and not supposed to be citizens of Israel. These are foreign nationals, right? This is a military occupation, and that if Israel made them citizens, it would be an annexation gesture, and it would actually violate the prohibition on the acquisition of territory by war. So we don't notice or mind, or in legal activity or diplomacy, we don't sort of note that this is a way to keep Palestinians from voting in Israel in ways that would alter the character of Israel, and that whole question for roughly 5 million people has been taken off the table. And domain 4 is refugees and forced exiles. It's hard to count this. We have the people who formally registered as refugees with UNRWA, the United Nations Relief Works Agency, but also people who are not and registered with them and all of their descendants, and estimates range from 5 to 9 million people. I struck threw a dart against the wall and said, let's call it 7. So I'm roughly 7 million people who are not allowed to return to Israel, specifically so that they will not be able to impact the Jewish national state. Now, this is the 4 domains, okay, and they work together. They are designed to work, we found, looking at them very closely. I believe Michael Safard was here not long ago. He's done a great deal of work on this. They're designed to work in a way that, in which each domain reinforces the operations of the other domains, that each functions to secure the exclusion of each domain from the capacity to change the Jewish national character of the state. This is another way to visualize that, that it is this is the regime. The regime is comprised of these 4 domains. Each has distinct laws and rules that ensure this one outcome, and they operate strategically together to ensure that Palestinians as a people can never challenge the Jewish national character of the state. Now, one thing I want to highlight here is that this, recognizing how the system works, tells us something a bit different from what a lot of people have assumed, which is that Israel's occupation, the one that gets the flags and slogans of end the occupation, and the one that consumes a lot of diplomacy in the United Nations and elsewhere, is absolutely essential to Israel. Israel cannot give up occupation and remain a Jewish state. In other words, in order to understand the logic driving Israel's otherwise inexplicable behavior in settling this territory and making a 2-state solution impossible, we find that the reason and the logic for that is coming out of the apartheid character of the state and the imperative of ensuring ethnic domination, ethno-racial domination. There's 2 reasons that this is the case. One is that Israel's, why giving up the occupation would threaten Israel. One is that Israeli withdrawal to permit a sovereign Palestinian state in the territory that Israel is now occupying would threaten racial miscegenation. Well, why would it do that? Well, any healthy state, any state that has a chance to grow economically, to provide for its people, to become a thriving society, has to have open borders in this part of the world. It's been recognized since the beginning of the Mandate Palestine back in the 1920s that this is a dense network of towns and cities and villages all working as an economic unit, and that needs to be sustained for people in the highlands of the West Bank and Gaza to function properly. Well, if you have open borders, then you have the free flow of populations moving back and forth, and when you have people moving back and forth freely, mixing, I don't know about you, but I think most of us know what happens when populations mix, okay, particularly young people, all right? There's babies emerge. The the racial segregation begins to melt away, and this becomes a threat to the whole construction of separation and the kind of apartheid system we saw in South Africa as well. So Israel cannot allow such a state. It cannot allow such a state to form because if such a sovereign state formed, Israel would have very great difficulty in sealing it off in terms that would clearly violate international law. The other problem is that full integration of the territory into Israel would require providing citizenship to Palestinians, and then they could vote, and then they could vote out the Jewish national character of the state, as I mentioned earlier. So Israel cannot give up the occupation. Being a Jewish national apartheid state, that logic drives its imperative of sustaining the occupation, and I think that's something a lot of people have missed, thinking that the occupation itself can be addressed separately. So this leads to a question that is highly pertinent to a current project going on in the United Nations, which is involves some states and diplomatic efforts, as well as widespread activism by people sympathetic to the Palestinian cause or mission, and that is to establish a state of Palestine. And there's a great deal of work done on this. I believe this graphic on the right shows the aim, the count. To, let's get 194 states to endorse, to recognize the state of Palestine. But as I mentioned, under apartheid policies imposed by Israel, such a state would be a Bantustan, which I'm going to talk about in a second. In fact, Israel, as long as it is an apartheid state, cannot tolerate a Palestinian state that's not a Bantustan, as I just discussed. And a Bantustan would secure permanent Palestinian poverty and underdevelopment, and it would essentially make the current situation permanent. I mean, what we see in the West Bank now is a formula for that, for national stagnation and unrest and discontent, and it's inherently unstable. So I think we have to rethink that, and one way to rethink it, recognize the imperative of doing so, is to take a closer look at the Bantustans. And anyone here who's interested in this topic, if you really are fuzzy about the Bantustans, as I certainly was when I went to South Africa in 2005, I really do recommend you just Google it. Get on Google. Spend half an hour reading about the Bantustans, because the more you read about them, the more they illuminate what's going on in Palestine as we speak, and the nature of the Oslo Accords in replicating the terms for the Bantustans in South Africa. As you may know, the Oslo Accords signed in 1993, and particularly the interim agreement of 1995, established areas in the West Bank that were to be governed by the Palestinians in varying degrees of autonomy. But what we find when we look more closely at them is that the terms of the Oslo Accords are almost identical to the constitutions of the South African Bantustans. If you go in and read the terms of the Transkei Constitution or the Ciskei Constitution, which are online, you can just pull them up. You find that they have arranged for a permanent vulnerability to the dominant powers, intervention and ultimate control in terms that really are uncannily similar. It's uncanny only until you remember that South Africa and Israel had very close ties for decades during the apartheid era. They were best buddies. They had extensive contracts that they shared. They had security cooperation and considered each other to be fellow travelers in the mission of surviving their geographic locations in seas of Black Africans or Arabs. So they were constantly exchanging ideas about how to do that, and it's illuminating to consider the extent to which the Oslo Accords replicated the South African Bantustans with some crucial differences, such as providing for elections to give the kind of panache of legitimacy to the leadership. The maps you're looking at here show a couple of, the top map is the Bantustan of KwaZulu-Natal. I could have put up several others. They're all, except for a couple of them, they were all composed as a cluster of cantons, a kind of a little archipelago of cantons, which again recall the areas of the West Bank and have the same function of dividing the supposedly sovereign territory into unworkable, disarticulated areas. This is listed as an inhuman act in the Apartheid Convention. It's Article 2D. And one of the aims here is to, and they were both called self-government authorities, by the way. The South African name was Black Self-Government Authorities. The Oslo Accords called them Palestinian Self-Government Authority. One aim of them is to channel indigenous discontent, the Black frustrations and ambitions to have a decent life and equal rights and fair life chances, away from the dominant power, away from the apartheid state, to their own appointed leadership. This kind of gets the dominant power off the hook. You know, now they are not responsible for these conditions. It's the Black or Arab Self-Government Authority. The top picture here is a famous photo of 9 of the South African Bantustan leaders lined up for a group photo during the apartheid era. And the bottom picture is, of course, the Palestinian Authority, which has now been written into the same kind of structural role. I don't mean, by the way, to impugn the integrity of any individual in any of these pictures, but I'm talking about a structural analysis of how the Bantustans worked. It's then this local leadership that represses dissent, which again gets the dominant power off the hook. And it also generates a leadership that's motivated to cooperate with the dominant power, because if they don't, they'll lose their jobs, quite simply. They will, and those jobs are lucrative. Even sincere nationalists put into this position may believe they're the best shot and that they should try to make it work. But they were formulas for permanent debility and subordination, and the ANC absolutely rejected the Bantustan system and called for the rest of the world to do likewise. I understand Nelson Mandela actually urged Arafat not to sign the Oslo Accord because he said he thought it would be, they'd find themselves trapped in the situation, and Arafat believed it could work and did it anyway. And of course, it hasn't worked out. Nelson Mandela's prediction was pretty sound. So now we have a portrait here of an apartheid system which has it operates by fragmenting the question into 4 domains. It has generated a system of oppression and political exclusion that secures Jewish national character of the state, and it has generated a Bantustan. So, fine, so what? What do we get out of this analysis? What does this inform us in any way? Does it change how we should be thinking about the conflict? Moreover, well, first, immediately, okay, apartheid is a crime against humanity. It has to stop. Any such crime, torture, slavery, it has to stop. There's a moral obligation to make it stop. And it is also seen as a threat to international peace and security. It's long been recognized that apartheid has that impact also to destabilize the countries around it, and that that is unacceptable. A number of solutions here. We know some of them quite well. First, the idea of partition. But obviously, the problem here is that if you partition the land so that the apartheid state is sustained in part of that land, you haven't ended apartheid. Okay, I mean, it was never considered in the South African case that there would be a white apartheid state in part of South Africa and black states in the rest of it. That was never considered admissible. Apartheid was considered to be a loathsome, odious form of racial discrimination, and it was considered that it had to end as a regime. Partition simply doesn't resolve that problem. It leaves you having merely shuffled the cards around a little bit and moved the border. And the apartheid and the related conflict that emerges from apartheid and has to emerge from apartheid by the nature of the oppression will therefore continue. There's a lot of talk these days about federation. Federation of two states, federation of regions within one state. I think the problem there is what I mentioned before, that healthy Palestinian statehood or healthy federal regions requires free demographic mixing that Israel cannot permit for the reasons I talked about earlier. And therefore, Israel will never be able to accept federation that would work for the Palestinians, and therefore we would have an unstable and unworkable and unproductive federation. That leaves us with, I may be being oversimplistic here, but I think, when you look at all the variations, you really do come around to the final one, which is unification. And I want to stress here that I'm calling it reunification rather than unification. And I want to explain why I'm going to do that, and then I'm going to try to wrap this up, because I'm probably going over my time really badly. Badly, yeah, oh dear, okay. Well, the alternative is to notice that settler colonialism is not resolved by withdrawal of the settler society when it's reached a certain point. It's resolved by eliminating the racial discrimination that has gone along with it. Then if we must therefore focus on the doctrine itself, the doctrine of apartheid. And I propose that we do this by treating the whole of Mandate Palestine as the state we're talking about. The legal basis for doing this is that Palestine was originally established in 1922 by the League of Nations as a non-ethnic state that would not discriminate among its citizens. It did include the idea that there would be a Jewish national home in it, but in Article 15 it specified that there would still be no discrimination within the state. And in 1922, the same year the mandate was passed, the British published a paper explaining what they meant by the Jewish national home, that it would be in Palestine, but it would not define Palestine. And there is an analysis of Resolution 181 in 1947, some of you may be thinking about, which we don't have time to get into now. But in the shorthand version is what I think we need to set that aside because it was never implemented and never could be implemented. So the last point I would say is that I'm not unaware of the challenges of reunification of Mandate Palestine. I think it is the only thing to do. It's the only way to end apartheid. It's the only way to resolve the conflict in any way that could possibly work. But it imports with it some very serious issues, such as identity changes. I mean, the idea of turning Palestine into one state that belongs to all who live in it is tough for people, especially those who have lost land and property and family members and hope to conquest. Jewishness would have to be reconceived as an ethnic identity without the national component. And that would be really tough for people, but it's been done before. It was done in South Africa when Afrikanerdom was turned into an ethnic identity. And Palestinian would also have to be rethought. And I don't mean to sound glib in saying this. I mean, I'm mentioning it because it isn't something to take lightly. But it's not possible to have an Arab state in a reunified Palestine in a country that's half not Arab. Okay, so if Palestine is going to be a country for all who live in it, the Arab component would have to be somehow translated into something that's immaterial to the ownership of the state or the central ideological mission of the state. All of these challenges were faced by people in South Africa. Just when we're feeling very daunted and saying this can't possibly work, we have to remember that it did work. and that it was done before, and there's a lot of precedent there to look at for inspiration. And on that hasty note, with apologies for the time overrun, I will thank you for the opportunity to share this with you. Thank you.
Thank you, Virginia. We give now the floor to Professor Robert Roth, who will comment upon the report co-signed by Virginia Tilley. Thank you, Robert.
Thank you, Riccardo. Thank you, Professor Tilley, for this speech and for the report. As we have not much time, as the topic is quite dense and intense, I will keep very close to my notes because I have a series of things to do, which I normally do not do. But I want to keep very close to my notes. So excuse me if sometimes it appears like a lecture, a short lecture. First, just to tell you that the discussion is not short. I'm preparing this discussion and other things on the issue of occupation more than apartheid, because I dissent on this, but it will not be the topic on the question of occupation. I came across a discussion in the Knesset, not directly, naturally, since I don't read Hebrew, in the Knesset in '85, and at that session, under discussion was a modification of the Basic Law, which is not as bad as the one which is discussed right now, and I will mention it at the end of my speech, but a definite different version of the Basic Law. And an Arab veteran lawmaker, Mr. Toubi, had made this speech. The bill tarnish the state of Israel as an apartheid state. So the notion of apartheid is interesting because it's 85, and probably it appears before, but I haven't gone through. So the idea of an apartheid state is not new, and that's its first point. The general reasoning of the report, if I may try to sum up what I read and what I heard. And what I read was this, the Basic Law of Israel. As you say, there is no constitution in Israel. It's Basic Law, the Grundgesetz, as in German, establishes basis of an apartheid regime, which subsequent policies and laws have stabilized. So there were the basis with the Basic Law of 48, and then it was stabilized. What I heard in the speech is a little bit different in my view, in my ears. Israel is inherently an apartheid state because of its Jewish and democratic regime or state. So a Jewish and democratic state is inherently and cannot be something else as an apartheid regime. And I agree on the first, probably, and I cannot agree on the second, because for me, this is not enough in order to verify if the regime, and I agree with the notion of regime, meets the conditions of the definition of apartheid, at least the legal, as you say, the discussion is legal, the legal definition of apartheid. This is what I will discuss in this short speech. To begin with the methodological aspects, just to come back to the race, it's a very delicate issue for a series of reasons. You adopted what I would call a functionalist approach. So Jewish and Palestinians are not innately racial in character, but what you are discussing is whether those identities function as racial groups in the local environment of Israel and Palestine. So it's only a functionalist approach, and I'm relieved to read this because the issue is quite delicate, as I said. I will accept that Israel, Jewish Israelis and Palestinians are races for the sake of the discussion and for the application of the Apartheid Convention and definition of apartheid. A connected question to this question of race since apartheid is the domination of a race vis-à-vis the other, is whether there is one Palestinian race or if you have to distinguish between the Palestinian citizens of Israel and the Palestinians outside the Israel which has been recognized in 1948. Your position is to say there is only one Palestinian quote-unquote race, and you shall not distinguish between the two dimensions or the two domains, as you call them. And I can understand why you do that. Naturally, it was obvious in your reasoning, but it leads you, and so you confirmed it in your speech, but it was not obvious in the report as far as I've read it. If you take this approach, then you don't distinguish between the situation of the occupied territories, where there is a right of self-determination, indisputable in my view, and the situation in Israel, in the 48 Israel, beyond the green line, where the question for me, but I understand it's not the question for you, is the equal treatment of all citizens of Israel, and I will come back to this. So you take the position that there is only one Palestinian race, and the Jewish-Israeli race is dominating the Palestinian race without distinguishing, except for the domains, the recognized state of Israel and the non-recognized occupied territories of the West Bank. It's a kind of, if I may use this word, maximalist approach, which I personally don't share. I will explain you why. But I understand the logics of your approach. The key notion of your demonstration, and I will not expand on that because I agree with you, but it's important for the audience, is the notion of a regime. So it's important to know, and on this I agree with you, that you don't apply apartheid on Wednesday and not on Thursday. Apartheid is a long-term process. The definition you give, sorry, I'm not a political scientist, so sometimes I find the political science definition as a little bit too loose, is, I quote, the formal and informal organization of the center of political power and its relation with the broader society. That's the definition of a regime. Bon, okay, so the question is whether apartheid is really a regime. I will distinguish, but you've done it also with the domain, the situation of the occupied territories, and I leave aside the question whether Gaza is still occupied. Let's accept for the discussion it's still occupied, even if there is no more Israeli Jew in Gaza. So the occupied territories on the one hand and the 48 state on the other hand. The question on the occupied territories is whether, to quote John Kerry, in the pivotal months of December 2016, when the Security Council voted a resolution condemning settlements, and for the first time without an American veto, in the same months, John Kerry said Israel could become an apartheid state. And the question is whether it's already an apartheid state or it could become. If I may be a little bit critical, the report, in my view, is very convincing in the refutation of the objections in the assertion that this regime is an apartheid regime, but I'm not entirely sure about the very definition of apartheid you use. And I will take here a legal approach. Unfortunately, you had the provisions under your eyes. They disappeared, but you remember the provisions. You have two bases, and we agree on this, the Apartheid Convention of 1973 and the Rome Statute provision, Article 7, on apartheid as a crime against humanity. As an international criminal lawyer, I insist on the fact that the provisions of the Rome Statute are provisions related to individual criminal responsibility, not state responsibility, and that you have to prove all elements in order to be able to convict anyone for apartheid. And beyond that, it seems to me that the definition, even if it's older, of the 1973 Convention is better in a way than the definition of the Rome Statute. You forget to mention one thing which is important in the Rome Statute definition, that apartheid is defined as you have shown, but within the general element of a widespread and systematic attack which you don't find in the 73 Convention. So I will discuss essentially the 73 Convention. As you have shown us, there are two main criteria. First, policies and practices of racial, quote-unquote, segregation, and secondly, the purpose of which is to establish or maintain the domination of a racial group over any other group. If you take these two criteria, what is already the situation in the West Bank probably meet them, and I agree with you. There is a set of policies and practices, and a group, a racial group, clearly dominate the other. The problem is nevertheless the purpose, and especially if you go before a criminal judge, you will have the problem of the purpose. Is there enough evidence out there that the discriminating policies and practices, a separate set of laws, separate roads, less protection of individual rights, is part of a deliberate policy? Well, we meet again the criteria systematic of the ICC statute. The report's answer is a loud yes. But my question is whether apartheid can really occur in an occupied territory. At least legally, this is disputable, and it's a pity that we cannot discuss at length the parallel with the Namibia situation, because South Africa was one state, and then you had the Southwest territories, as they were called, and when South Africa invaded the Southwest territories, they brought with them the apartheid. So they brought apartheid in an occupied territory. This was brought before the International Court of Justice, which issued a series of decisions, and especially in 1971, it's interesting, 2 years before the Apartheid Convention, an advisory opinion where, unfortunately, the question whether apartheid can occur in an occupied territory, strictly this question is not really addressed because there were a series of reasons why South Africa anyhow infringed international law. For me, and I will be very direct, the use of apartheid misses the target. Why? Under AHL, the obligation of the occupying power comprised the maintaining of the legal statu quo for the occupied population. This is the basis of the laws of occupation. Therefore, an occupying power, respecting its obligation, would have two legal systems, one for its troops, and one for the civil population, and if possible, the regime, or the legal regime for the civil population should be exactly the same as before the military intervention and before the occupation. Naturally, in Palestine, it could be a little complicated to determine which legal regime would apply for the Jordanian law, etc., but let's keep it like it is. There is a first infringement by applying military law to the occupied population on the long run. But this is a violation of the law of occupation, and for me, it's not apartheid. The second violation of AHL, the major one actually, is colonization. Settlements per se infringe on AHL, but it is not the debate here. Then here you have two different laws. This is a normal situation of occupation. What is not normal is the colonization and the massive presence of settlers without any cause related to security, because settlers can be accepted in occupied territory only if it's related with security concerns for the occupying power. Beside the legal situation, there are naturally concrete policies, and I will not expand on this. But legally, the use of apartheid misses the target, as I said. In a way, Chomsky was right when he said or wrote a couple of years ago, apartheid is a gift to Israel. Because apartheid is a kind of recognizance of the validity of occupation and kind of recognizance of annexation. So the day when there will be an annexation, and probably it will come, unfortunately, or when the creeping annexation which takes place this day ends, the application of the laws of occupation will also change, and then you will have two legal regimes discriminating one group vis-à-vis the other in one territory. But this is not, for me, the situation now. Under ICL perspective, if I may come to my discipline, it also a little bit misses the target because the most relevant conduct is in my view, the violation of the laws of occupation. And especially because it's completely clear in the Rome Statute, and there is no discussion on this, I quote simply the Rome Statute, the transfer by the occupying power of parts of its own civilian population into the territory it occupies. Article 8 2b8 of the Rome Statute. For the crimes against humanity, and especially for apartheid, naturally the problem of evidence, for instance, would be much more complex, especially the personal responsibility vis-à-vis the apartheid situation and the widespread and systematic attack condition. And as I say, I regret there is no more room for discussion on the situation on Namibia because it's the most relevant situation. Naturally, if you consider that the occupation will necessarily lead to annexation and that annexation is the only outcome, all my arguments fall. But this is, for me, a kind of self-fulfilling prophecy because, and I think we, as an international community, and I personally, have to fight against occupation. And in the fight against occupation, for me, as Chomsky has said, it's a little bit provocative, but apartheid is a gift to Israel. That's the situation for the West Bank and for Gaza, and sorry to be short, but I don't have much time. Then the situation in the 48 Israel state. The report considers, you've heard it, that it is inherently an apartheid situation where you have two different populations and one dominates the other. The report concentrates not so much on the policies and practices, even if they are mentioned, housing and residence restrictions, budgetary uneven distribution, but more on the distinction between citizens and nationals, and I have to stop here for a short moment because it's very important in the discussion. To put it simply, all residents with an Israeli passport are citizens, and it seems to me that the demonstration report alleges that only Jews are also national. This is not entirely true or accurate because the situation is more or less the same as the Soviet Union. Mutatis mutandis, but you had the same situation in the Soviet Union. All persons with an Israeli passport are citizens, and there are 5 nationalities recognized in the basic law: Jews, Arabs, Bedouins, Circassians, I don't know how you say it in English, and Druze. So you have 5 nationalities, not one. And the question is whether the system, the regime, organizes the domination of a nationality over the other. I have no doubt, not the first doubt, that the Arabs and the Bedouins even more, if they distinguish like in the Israeli law, that the Arabs are discriminated. But in my view, if you use apartheid for what is for me a major discrimination system, you overuse the term of apartheid, and in this sense, you weaken it. So let's consider completely what is at stake. You have Israeli citizens, and the Declaration of Independence say the state, you didn't quote it, so that's why I quote it, will uphold, I quote, the full social and political equality of all its citizens without distinction of race, creed, or sex. So the 48 Declaration. So in the Declaration of Independence and in the Basic Law, there is equality, at least legal equality, among the different nationalities. Your demonstration relies a lot, is based a lot on the work, and it was also on your slides, on the work of agencies which aim at bringing more Jews in Israel, that's for sure, and which aim essentially at that, the Jewish National Fund and the Jewish Agency and the Zionist, World Zionist Organization. This is true, but can you allege and assert that this is apartheid simply first because the state is defined as a Jewish and democratic state. Second, because you're right, somebody who is elected to the parliament cannot contest this base of the state, and thirdly, because they are agencies on the ground which have the aim and the mission to bring more, to put it simply, because it's not as simply as that, to bring more Jews to Israel. In my view, these are points which can be disputed, but in my view, there is not enough evidence on policies and practices which impose the domination of a racial group over another within the 48 borders of Israel today. Which does not mean that tomorrow it will not be the case. And I made a small mention at the beginning of my speech to the present discussion, again, of a new basic law before the Knesset, which probably would introduce an apartheid state. What is at stake? So it's a bill which has been introduced by the Ministry of Justice, Ayelet Shached, who the bill was stalled for a couple of months, and it has reappeared recently before the Knesset. It's in discussion before the Knesset. It will probably never become law as such, because probably the Supreme Court will not accept it, and even the Attorney General of Israel considered it contrary to the basic law. But it's important to quote what this bill proposes. This bill proposes that the state, the equal rights of the Arabs will not be mentioned any longer in the law. It's still in the Declaration of Independence. And according to this bill, I quote Mrs. Shached, who said that last week before the Knesset, Zionism will not bow its head to individual rights. So it's a major trend. It's a major trend in other countries too. Naturally, it rings a bell for the ones who are following the situation in Poland, in Hungary, in Turkey, in Russia, etc. And it means that the notion of equal rights for the individuals and for the groups will not be prioritized vis-à-vis the Zionist character of the state. If this becomes, in a way or another, a law, naturally it will be amended. But if it becomes a law, I completely agree with you that it's an apartheid state which will be in place. For the moment, I'm not convinced that all the conditions, as I said, of the 73 conventions are met, and I'm not sure that strategically, and if you want to end the occupation, the argument of apartheid is the most relevant one. That was my little bit critical assessment, but thank you for the report and for the speech.
Thank you, Robert, for this brilliant discussion of Virginia report. Maybe before giving the floor to the public, Virginia, would you like to? Okay, that's fine. So the floor is yours. There are a number of questions here. Thank you. Here, on the left. On the left. Okay. No, it was first of all up there. Yeah. Here. Then. You raise the hand. No. So upstairs. There.
Thank you for both panelists for this nice debate. I think it's very interesting, and we learn a lot with this. And I tend personally to agree a lot with Virginia Tilley. And I had two remarks regarding Robert Roth on his presentation, mostly on the exclusive application of occupation law and the notion of apartheid. I don't think it's necessarily excluding each other. I think you can have an apartheid situation within the occupation situation, because actually occupation situation should be like temporary. And the occupation situation has been on and on since 1967, which is like a long situation that is not the usual stage of an occupation situation. But there is also, I think they learned somehow from the South African experience, because they've seen that if the state indeed include the West Bank territories within its own territories, then it will be blatantly occupation, apartheid situation. So they use this occupation situation to actually implement this stage of like discrimination. But they know if they go further, if they are like, as you said, if they give either like the independence or they include all the citizens, Palestinian citizens within the country, they either have to discriminate them, which will be blatant apartheid, and otherwise they will have to allow them to be like Israeli citizens, and then the democratic balance will be in disfavor of the Israeli state. That's for my first remark. And I think regarding the within the Israeli state, 48 Israeli states, I think it doesn't work separately from the rest of the apartheid analysis. You have to look at the different domains together, because otherwise you cannot say it's an apartheid situation if you look only at the 48 Palestinian states. But the whole logic is actually, if you look at the different territory situation, because then you create different categories for Arab citizen, Palestinian citizen, Bedouin, non-Palestinian, Palestinian without passports, and so you fragment the Palestinian nationality in order to weaken it, and to prevent the nationality to use his right on his territory.
May I just answer 2 words? Sorry, Virginia. Sorry, 2 words. For the first, it's interesting because your argument is exactly what I say. What you are denouncing is the violations of the law of occupation, which is a film. You're completely right, 70 years is too much. Occupation is legal, but the extension of obligation is illegal. I'm 100% with you, but this is not apartheid. And secondly, you are a little bit reasoning like the Israeli government. Because in one way, the Israeli government say international law, put it simply, does not apply, especially in special. But Israel is based on international law. And it's important to remind that one state is recognized by international law, it's a 48 state, and in my view, it must be asserted that it has a right to exist, which means that the rest is illegal. If you blur everything, saying 48 states, 67 boundaries, finally are just a way to discriminate between Palestinians, you blur everything. And self-determination for the Palestinian citizens of Israel raises huge problems vis-à-vis international law, whereas self-determination for the citizens of the West Bank is completely acceptable and accepted.
Virginia, you wanted to answer on that? Okay. There was over there. Sorry. Yeah.
I don't want to duck anybody. I'm just...
Yeah.
Thank you very much, Professor Tilley. Professor Roth is a professor of criminal law, and I want to talk about crime and punishment. You talked a lot, Robert, about occupation. You were more comfortable with that than apartheid. What about punishment? How would you weigh the potential for punishment for either going against the laws of occupation or going against both the crimes? Are we talking about eventually punishment? You mentioned it would be difficult with apartheid dealing with individuals, but how would you weigh the two in terms of eventually some kind of punishment? What does it mean to do a crime against humanity?
Let's take maybe a couple of more questions. There was a question there.
Thank you both for the discussion, and I just had a few comments more than necessarily questions. My name is Rania Maharib. I'm a legal researcher with Al-Haq, so we came from Ramallah for the Human Rights Council. And I have to say, Professor Roth, there are some points that you raised that are quite preposterous, I have to say, I'm very honest. The point on self-determination, I'm very sorry. How can you say that self-determination only applies to a portion of the Palestinian people? How can we say that a part of the Palestinian people with different citizenship status that was imposed on them without their will makes them a different race? I think it's an absolutely preposterous suggestion to say that just because Israel did not displace a quarter of the Palestinian people in 1948, that portion of the Palestinian people today is not part of the same people that we're talking about in 67, and the same people we're talking about who are refugees in exile. And I also have to say about the question of occupation, yes, we are in a situation of 50 years of occupation, 50 plus years, but occupation alone does not really clarify what's happening in Palestine. And occupation is not the basis of what happened in Palestine. The Palestinian question existed 20 years before the occupation started. So what about the refugees? What about Palestinian citizens of Israel who consider themselves citizens, and I'm one of them, who are still Palestinian, who are entitled to the right to self-determination, which was recognized to them by international law before 1948, and that is under the League of Nations mandate for Palestine. So the League of Nations mandate itself recognized the right to self-determination, which the ICJ reaffirmed in Namibia, if we want to compare to Namibia. So that right has already been reaffirmed, and in Namibia the court even said retroactively that this was the intention of the League of Nations mandate. So we're talking about a document that already existed before 1948 that didn't necessarily speak about the Palestinian people, but spoke about the peoples of Palestine, the inhabitants, the original inhabitants of Palestine, 3/4 of which have been displaced and are still in exile. And now we're talking about 5 to 6 million people who are recognized refugees. All of these who, this year we mark 70 years since the Nakba. I'm just very sorry. How can we consider that we have different peoples that we're talking about? Yes, we have different fragments, and that is part of the apartheid regime that the Esquire reports discusses. Fragmentation as a tool of oppression and a tool of apartheid. And that's exactly what we're looking at here. I think I agree with the previous discussant that apartheid, occupation are not the only frameworks that are applicable in Palestine. We have different frameworks, and one does not exclude the other. That is in reference to your question on occupation law and IHL. I'm sorry, it was a bit long.
Thank you. Thank you. Let's take another third question. No, over there. Let's take the two questions over there. Wait. No. Sorry. Okay, please.
It's a very awkward moment. Okay, thank you very much. My name is Param. I'm a PhD in international law here at the Graduate Institute. So I would like to, well, calling it apartheid or whatever, I mean, it's fine. I'm more into the solution. Let's find a solution. And your solutions, Professor Tilley. First of all, I find a sort of intrinsic difference between the situation right now in Israel-Palestine situation, the whole place, and also in South Africa. The thing is that, in my view, what happens right now in Israel-Palestine issue is this very intrinsic and natural kind of conflict between the three Abrahamic religions. That did not exist in I mean, these three religions, and I'm just talking from just my own atheist view, are all the three of them are genocidal, suicidal, and racist. I mean, there is, and they mean to destroy one another, and that's the history that we lived through for more than 2 millennia. So that did not exist in South Africa. That is being the one point. And the second thing is that, okay, you say that Palestinians should give up their Arabness and Israelis should give up their Jewishness and all these things. So one state solution, what is the common factor that makes a single nation state? What are these people all together other than being human, considering that human seems not to be enough for all of us to be one? We always need to be something else. Well, so what unifies these people who are devoid of Jewishness and Arabness and Islamicness and everythingness of their existence? Thank you.
One last question for this tour down here. Yeah.
Thank you very much. My name is Adeline Mills. I'm a consultant on peace and conflict. I also happen to be South African. And my question is more for Virginia Tilley. I was very interested in the reason why you would take an analysis based on comparing Palestine to South African apartheid. What was the point of doing that? Because I don't really see the point. You came up with some solutions that were completely unimplementable. We've been having reports and reports about solutions on Palestine. What are the actual proper solutions that can actually be implemented? It's not implementable. So the three solutions of trying, the one-state solution is probably the only solution that is implementable. However, you mentioned giving up on certain identities, certain concepts of ethnicity, taking away and forgetting the whole history of the Jewish population, which the South African population doesn't refer to historical suffering of the white population in South Africa. There's no such discussion. Whereas the Jewish population have such a justification for what they're doing there. It's an historical justification, which South Africans didn't have. So I just want some talk about proper implementable solutions. Thank you.
I think that if you want to answer to these questions, and then we do a last, second and last tours of question. Virginia?
Yeah, I'm scribbling away here. Yeah, quickly. Well, being an academic, you always never want to hear an academic say quickly because you know what's going to come. Okay. On the Palestinian right to self-determination, I think in international law, this is really incontestable. This was affirmed by the ICJ and the Wall opinion and so forth. Besides the fact that the Palestinians would never put up with being told they didn't have it anyway. However, the question there becomes a kind of an ontological question of what is Palestine, right? What is this? And I'm so glad you mentioned that language of the mandate of inhabitants, because this is usually cited as evidence that the mandate had no intention of recognizing the Palestinian population as a people. Whereas it used that term for the Jewish National Home Project. And I think that was a misreading. I think the idea was that this would be a territorial civic nation. And I think when you look at the mandate history, that's very clear. So I'm really glad you mentioned that. But it does alter the character of Palestinian national self-determination to go back prior to how that was reconfigured by the Zionist project to extract Jewishness out of it, and therefore it led into this kind of 1960s construction of Palestinianness as explicitly Arab. Now there's lots of reasons why it is Arab, as an Arab population, Arabic-speaking population, but these identities, when they are politicized as national identities, is what we're talking about here. And I just wanted to kind of endorse your analysis there, and unfortunately I don't think we have time to flesh that out very much. Abrahamic faiths and perennial conflict, sorry, I'm just going to kind of set that aside. But I did want to, because I just don't think it's empirically, provable. But I do want to stress something that a lot of people don't know about South Africa, and that was that it had a very powerful religious component. The Afrikaner ideology was just really, really deeply shaped and steered by Calvinism. And it was a highly religious view of Afrikaner identity, and of course this is the indigenized Dutch settler population, and the relationship to God of the kind of pre-chosen people. The landscape was labeled with biblical references. The sanction to govern was understood to come directly from God. So, these are fascinating questions about the South African case that I did go to learn more about. You've got a good point in saying, well, if the comparison doesn't matter to the universal instrument, then why do the comparison? But I didn't know that in 2005. And anyway, since we're always talking about that comparison, I think it behooves us to know more about it. And it did, in fact, prove quite illuminating to me in understanding how apartheid was instrumentalized and codified under Israeli law. A little bit of, I suppose that's sort of a research defense, but that was that. What is the basis for national unity? I don't know. This is again where the South African case becomes useful as kind of thought experiments. It's like, well, how do they do it? Okay, and what's lost now to memory for a lot of people is that they were South African debates were deeply divided on this question. That it was not a simple thing. It was not one ANC-led vision of one state for all who lives in it. There were deep differences about this. People were arguing for multinational states, multiracial states. Some of them were arguing for partition. There was all kinds of trouble in 89, 90, 91, as people were confronting the collapse of the apartheid system and had to agree on what it was going to be. And here we come to something rather crucial, which is you can have, I don't mean to say, and I apologize if I conveyed this, that identities have to be just given up. What we can do with identities, such as an ethnic identity or religious identity, is alter its configuration in a political discourse, right? You can say, I'm Arab, but that's just, you know, that's my identity, and it doesn't actually, you know, steer my contribution to the country, or it doesn't politically determine how I fit into the national corpus, right? Or it does. Okay, I mean, that's the problem. That's why I kept stressing the formulation Jewish national. Okay, because in Jewish national discourse, Jews are a nation. They are a people with the right to self-determination. You don't give up being Jewish. Okay, I don't think even any rational human being would expect to go into any setting such as this and expect to just twist knobs and have people change their understanding of who they are. But it is possible to twiddle knobs and change how they understand those identities to fit into a national identity. And a lot of countries have done this. They have said, our country will not be steered by any one religion, for example, or our country will not be steered by any particular ethnicity, or racial discrimination is outlawed. I mean, these identities can be deformalized. They can be turned into the private sphere. Now, people who think that's easy to do, I think, are naive. So I do agree with that. But I hope I didn't convey the idea that people can just undo identities. That's not the way they work. But you can change how identities are politicized. The South Africans came up with the solution, for example, of saying you cannot have any political party based on a racial identity or an ethnic one. They made that illegal, okay? And it forced parties to come up with other ways of expressing their concerns. Anyway, I think I've gone on long enough, so I'll give that over to you. But I appreciate all these comments. It's really very interesting.
I will be very short. Sorry, I'm too pragmatic. That's the answer to Danny too. I'm too pragmatic. I know discussion 22, 47, 48, 67. We can continue and continue. The problem with the right of self-determination within the recognized, internationally recognized borders of Israel raises major problems under international. How do you implement it, etc. On the principle, probably you're right, but be pragmatic. Sorry, I don't have to lecture you. Be pragmatic. You can stop settlement. You can stop at least new settlements. Probably some damages will not be changed, but you can stop, and you have tools for that. But I don't have to lecture you, and that's why I'm so convinced that the approach under the law of occupation is the right approach. But it's my view. Danny, the same more or less. Perhaps you can prove the crime of apartheid, but for me, it's a crime of apartheid, not the practices of apartheid. For me, simply, it's difficult to prove, and whereas the other, the war crime of displacing population, both because there are also displacements, especially in Jerusalem now, of Palestinian population. This is a major crime which occurs now, and which you can have a court to decide on it not very, but quickly. The apartheid, because it's a crime against humanity, and as I said, you shall not, in my view again, overuse the notion of crime against humanity. I will be cautious. That's all. I don't say it's not provable. I don't say it's a wrong route. I think the right route is to continue to fight occupation.
I know it is 2:30, but maybe there are people that still have questions. So in case you want, we can stay more 15 minutes. So just let me do a remark if I can, because it is very interesting what is coming up through your presentations and the questions in the room. When we come to the question of different forms of discrimination, I think that if we put into perspective what happened with the creation of the State of Israel and the region at large, the Near East, the big deal which has not been solved is the transition from a logic of empire to a logic of nation-state. The Ashkenazi Jew brought from Europe their own view of a nation-state into Mandate Palestine. And from 48 onwards, they applied a number of discriminatory practice, by the way, not only in relations to the Palestinians from Israel, but as well as between Sephardi Oriental Jews and Ashkenazi Jews. So you have there, and then you had a different kind of racial denomination. When we talk about the Bedouin, this is not specific to Israel. In terms of discrimination, the Bedouin have been positively discriminated in Jordan. They are overrepresented in the parliamentary system. They have been, again, positively discriminated in Syria during the Mandate period because the French wanted to create a Bedouin state. So you have this question of old identities and emergent identities under state control, who signal definitely the big problem of this long transition from one of the last empires, the Ottoman Empire, to the reality of the nation state. But what troubles me in some elements of the discussion is how you frame different, I mean, Virginia, you are giving, if I may say, a sort of a picture, which is static, but there are different historical periods where different forms of discrimination have been emerging or developing. When I think, for example, to the Palestinian citizens of Israel or the Druze, the discrimination already began during the 1948 wars. Because while Palestinians in the villages in today Israeli territory were pushed away, the Druze never. The Druze were not expelled. On the contrary, they were considered being among the first allies or collaborators of the Haganah or Irgun or Leh or whatever. But then you had a period of military administration from 1949 up to 1966. So, and there, what is this? This is a clear discrimination, very strong one. Before the military occupation was enforced after 1967, you had it in Israel proper for the Arab population. The Arab meaning also the Bedouin. They were forced to settle, etc., etc. So what they were forced to settle? The Bedouin of the Negev. Those in the Galilee were already settled, but those in the Negev were still roaming. And the problem was they were crossing over Jordan and the Sinai. Now, my point, according to this, how you would conjugate in this debate on apartheid today, when I say you give a picture and consequences. There is a movie behind, there is an historical depth with different forms, which in parallel also echo evolution of international law. Because today, I mean, since 10 years, somebody, an historian like Ilan Pape says, but 48 is an ethnic cleansing, which was never thought or was never demonstrated before the 80s. So we are in a context where what you are presenting, fine. The point is which breadth you give to an historical analysis where we come to today's situation and how the different analysis of jurists, social scientists, etc., echo together. Sorry, I'm a bit long, but I was very much thrilled by what you were saying. Let's have another couple of questions, maybe.
She's the main speaker.
No. I mean, I really do want to hear from the audience, but I just want to endorse the importance of a historical sensitivity to the evolving historical environment. And that, I think, is why Tony Judt in 2003 described Israel as an anachronism, because he was looking at that evolution of norms and seeing that the ethno-nationalism of Israel today is hearkening back to the normative formation of a modern state, a nation state, as it was conceived in the 1920s and 30s, more than it is now. Okay, there was a kind of a mid-century shift there that wasn't complete, obviously, and wasn't all at once, but there was a rejection of racial nationalism because of the ghastly consequences of it in the Nazi case and in the Imperial Japanese case. So that today, in modern, I would say modern in the meaning contemporary human rights law, is really now settled on the idea that the discrimination among citizens is not okay. You're really not supposed to do that. What I found really interesting was that way back in 1922, when the mandate was written, that same principle was very firmly stated. Right in the heartland of racial nationalism, the idea that this would be a non-discriminatory state was very forcibly put forward. And there was this Jewish national home quality, which I think complicated that. It was a kind of an acknowledgement of that primordialist kind of understanding of identity that imported that into the mandate. But right back there are the seeds of this non-ethnic, modernish state, sort of 21st century state that they were affirming then, and that was partly because Palestine was obviously a multi-sectarian at the time, and they had to, everyone knew that. And I had another really good point to make, and now it's eluded me, I think. Oh, I know what it was. I do think that the apartheid analysis raises grave questions about whether Israel is a legitimate state. And if it is not one, I mean, a regime, in the sense of being a regime, just, use the South African case as kind of a little thought experiment reference. And if that is the case, then what we are talking about is not Israel withdrawing from the territories. It's not Israel, this apartheid state, this racially constructed state that is the state we need to be thinking about. The state we need to be thinking about is the 1922 Mandate Palestine, which was never partitioned properly. It was never successfully partitioned. It endures the legacy of that failure to this very day. And there is this residing behind this thing in which we're so obsessed, two states, one state, who's supposed to do what or withdraw from who or what, all of that is playing out over this original state, which is still sitting there waiting to be fulfilled. And I find that a fascinatingly interesting and potentially transforming paradigm shift in understanding what it is we're looking at. So thank you for giving me the opening to offer that.
So let's take maybe another couple of questions. There is a question here.
Thank you. Thank you for the interesting event. I would like to give it a different angle.
Just make it closer to you.
Okay. It seems to me that if we continue to look, if we can compare it to apartheid, if we are speaking about religions, it seems to me we'll spend the next 2 centuries not solving the situation in Israel. I would like to ask the international law experts, how do you see it? Why not emphasizing or concentrating on allowing equal access to equal human rights? Starting from that, it doesn't matter where you live, what your religion is. It matters that if your wife can have access to water in the territories, my wife should have the same. N'importe her religion, her status, the 48 states, the apartheid, will never end it. It seems to me that only agreement and enforcement of international systems, international law, institutions, that each person deserves equal access, not only saying he deserves equal human rights, equal access of any Palestinians in Israel, of any Arab in Israel, to the same equal human rights that Israeli people have in Israel. For me, that's the only solution that I can think of. Very good.
I have been interested, I'm a Korean, coming from South Korea. I have been interested in the Palestinian situation since 2006. Knowing some of our friends struggle in the Palestine-Israeli situation, I think the political analysis in terms of apartheid has been very informative to me in its details as well as its implications. I always had our friends appealing to the international law has been always feeling that somewhat not quite satisfied to solve the problem of people's the basic rights, their right to life, and so on. And perhaps this would be my question. These are not these are the questions, analytical tools, and understanding, perhaps a bit short to reach the bottom of the questions, particularly when you look at the geopolitical impact on this situation where there is already apartheid, there is already nation-state structures that has been very much influenced by the Western civilization development. Perhaps this is the time now we think a little bit more how to, for example, handle the global market, the impacting this apartheid situation, this international legal situation, how the geopolitical equation today, particularly like Mr. Trump is making a big statement, how that has an impact on this analysis that we have. So I'm just to myself, there should be probably much more convergent and far-reaching analytical understanding. It's in the sense that I appreciate the analysis, but at the same time, I feel miss something to go beyond.
I give you the floor for answering, and then we have to conclude.
Oh, no,
Perhaps it's better if you conclude, no?
Oh, me?
Because I don't want to conclude.
Oh.
You are the main speaker. Okay.
Well, I guess, I mean, I'm more absorbing, the tenor of all of these questions, and I appreciate how much they're helping me to target and improve my own thinking on this. But perhaps as a closing statement, I could say that I think the shift to an apartheid analysis is a momentous one. I don't think it's just a kind of technical flourish of international legal scholarship in the ivory tower. I really think that this is all things, for me, as someone who's looked at this conflict for a long time, and I know there's others in the room who have done likewise, but I have looked at this for a long time, and that we just constantly confront anomalies. Why does Israel build these settlements? Why don't they withdraw these things? Everyone is saying that they will become an apartheid state if they keep it up. Then why do they keep it up? Well, they have to keep it up. All right. The apartheid analysis illuminates these logics. It explains so much. The nature of the Bantustan, the splits between Hamas and Fatah. All of these things suddenly are just forming this picture of one regime, one problem. And it's not that these other things don't matter. It's not that the law of occupation doesn't apply or any of these. And that was a really good point, I think, that was raised, that you can have multiple forms of law or areas of law applying at the same time. Human rights law, international humanitarian law. But this is to take that as the originating doctrine, to say that this conflict cannot be resolved until Israel gives this up, alters the trajectory of analysis as well as diplomacy. I think there's great potential here. It is tough, it is really tough to mess around with these identities that people hold so near and dear, and that they will fight to defend and believe are existential questions for them. They believe that this is going to, they're going to die. They're going to have their throats slit and thrown into the sea if they give up these ideas. But that's part of the challenge, is to find that synthetic, syncretic, vision of the nation. I agree that that's lacking. It's lacking on purpose. It's lacking because it's been stamped out of existence by Israel. It's missing precisely because it threatens the entire system. So I actually feel very optimistic about this. I don't see it as a stick to beat Israel with or something. I see it as an analysis of what the driving forces are, the driving logics and senses of imperatives are, that if we put that at the center of the question, then we can begin to take steps we couldn't do before. We can begin to see one integrated state emerge from that analysis. We can begin to see a higher vision of it. And I don't want to get maudlin here, but there was an element of inspiration to the South African success story, which matters. That there's some kind of higher human calling for seeing each other as human beings. I mean, that can be liberated by a different analytical formation, and it is blocked by others. It's blocked by the two-state solution. It's blocked by ethno-nationalism, and this can really constitute a Thomas Kuhn type paradigm shift that will really make a major difference here. I don't want to. I'll stop there because I'm starting to sound like I'm thumping my own report, and I don't mean to do that. It's just that this is where I've kind of arrived, and I therefore share your concerns and your questions about how it would manifest. But I do think it's a very promising line and I haven't felt so optimistic about this conflict in a long time. So, I just thank you for the opportunity to sit with these two, tremendously experienced people and listen to your comments and think more and more deeply about this. So I really appreciate that. Thank you.
I will continue not to please part of the audience, but no, I disagree. I respectfully disagree with one point, and I find a small contradiction in what you say. I don't think they cannot, I want to quote you, they have to keep it up. They have to keep it up, the discrimination. It's deterministic, perhaps I'm too optimistic, but it's deterministic, and I find a little contradiction between saying it's done, it's an apartheid state, they won't change the character of the state. At the same time, we want to implement the 1922 mandate, which is naturally very unrealistic. I'm all for it, but if you say that it's really what we have to implement, and I agree with the gentleman up there, then we won't go very far. So I think Israel can stop, and here to link it to the second question, can stop. Don't forget it. They can stop, and there are you about the international law and law in general. I just wanted to just answer briefly your point. Law doesn't solve problems. Law only gives words on situations and words on solutions which can, but never has any decision change anything on the ground. You need people to implement it on the ground. And international law even less. The fact is that international law here gives a lot of tools, and these tools must be used in order to stop the colonization and to stop the road to apartheid, or the apartheid, in the occupied territories. So international law is not without teeth, and you have to use really international law at every moment when you take the floor and discuss the question in the West Bank. Perhaps I'm too pragmatic, but really you have to, my view is that you have to focus on it.
Thank you, Robert. Just one, I would like to conclude going back to the point made by our colleague of Al-Haq when she mentioned the question of the Palestinian diaspora. Actually, whether we call it apartheid or discrimination or different forms of discrimination, Israel, by lifting his regime, and I fully agree with what Virginia explained, what a regime is, could be a real revolutionary state. It defends itself as a Jewish democratic state, is certainly democratic for its Jewish citizens, not for the others. But can you imagine if this would happen, it would be a blow in the region. And that's why I'm thinking about the refugees, because the discrimination against the Palestinian refugees in Lebanon, Syria, Jordan, these other host states would probably find it more difficult to keep the discrimination regime against the guest population. So, yeah, I really hope that whatever you suggested, something would come up, and I really thank you for the high-level debate that we could have. Thanks for having accepted the invitation.